Holiday parties are coming. And right now, your managers are probably about to make statements that sound like harmless small talk, but create instant EEOC liability. According to a recent EEOC case, a sales manager's conduct at a Wireless World LLC holiday party resulted in a $107,916 settlement. And these same types of violations are happening at office celebrations and year-end events every single year. Here's the hidden danger HR departments might miss about company social gatherings. I'm Alex Castro, a Florida licensed labor and employment attorney with AXC Legal located in Fort Lauderdale, Florida. I help South Florida businesses build compliant workplace culture and defend against EEOC charges that start off with off-the-cuff manager comments at social events. Remember, this is general information only, not legal advice. Every employment situation is unique and requires individualized evaluation. You probably think your managers understand boundaries. You've done harassment prevention training, you've gotten written policies, you've reminded everyone that company events are still work events. Your process feels legally protected, and most HR teams have similar protocols in place. But here's what the EEOC sees differently than you think. Holiday parties create a perfect storm for discrimination claims. Alcohol loosens tongues, social settings blur professional boundaries, managers forget they're still supervisors, and every inappropriate comment becomes documented evidence in EEOC complaints. According to employment attorneys who handle these cases, holiday parties have unique potential for harassment because they combine relaxed social environments with accepted alcohol use. This HR practice looks like team building, but actually creates liability that plaintiffs' attorneys search for in every discrimination case. Even experienced HR teams can miss hidden traps buried in casual holiday party conversations. Today, I'll show you 21 dangerous things managers say at holiday parties that are costing companies tens of thousands of dollars and exactly how to prevent these statements before they trigger six-figure EEOC charges. Your manager is at the holiday party. A female employee mentions she and her spouse are thinking about buying a house next year. The manager, trying to be friendly, says, "Better do it before you start having kids," or "You guys planning on starting a family soon?" Or even, "Clock's ticking if you want babies." The manager thinks they're making small talk. They're showing interest in employees' lives, maybe even being a little funny. The comment feels like normal social conversation at a party. But here's what employment attorneys know that HR may not know. Any comment about pregnancy plans or family status is evidence of sex discrimination, especially when it comes from someone with supervisory authority. According to EEOC guidance, harassment based on sex, including pregnancy, becomes unlawful when the conduct is severe or pervasive enough to create a hostile work environment. And it's unlawful even when someone thinks they're making a cute little joke. When managers comment on employees' reproductive choices, the EEOC evaluates whether this creates a pattern of treating women differently based on potential pregnancy. Here's what catches even experienced HR teams. These comments become exponentially worse when connected to employment decisions. If that female employee doesn't get promoted 6 months later, her attorney will point to the holiday party comment as proof the manager was tracking her family planning and factored it into business decisions. After all, they needed to put the most reliable person in the role. According to EEOC remedies data, compensatory damages for intentional discrimination based on sex can reach statutory caps of $50,000 for employers with 15 to 100 employees, $100,000 for 101 to 200 employees, and $200,000 for 201 to 500 employees, and $300,000 for employers with more than 500 employees. But that's just for the emotional distress type damages. These settlements typically include back pay, lost benefits, and emotional distress damages that skyrocket the total bill. Here's how it plays out. Manager makes family planning comment at a holiday party. Employee applies for promotion in March. Someone else gets the job. Employee files EEOC charge in April citing the holiday party comment as evidence of discriminatory intent. The company's own witnesses confirmed the manager said it and kept talking about it for the next few weeks. Settlement negotiations start at $40,000 and only go up from there. Here's the checklist I give every HR team before any company social event. First, train managers that all comments about pregnancy, family planning, fertility, or having children are completely off limits at work events, even in social conversation. Second, if employees bring up their own family plans, managers should acknowledge neutrally and redirect. That's exciting for you personally. How are you feeling about the Johnson Project deadline? Or, have you seen any good movies lately? Third, never comment on whether someone should or shouldn't have children, when they should do it, or anything related to their reproductive choices. Not only is it rude, it's just weird. Fourth, if a manager makes these comments despite training, document immediately that they corrected themselves and looped in HR before any employment decisions are made affecting that employee. Fifth, remind managers before every social event. If you wouldn't say it in a performance review meeting, don't say it at the holiday party. That protects you from pregnancy discrimination comments, but without this next protocol, you're still exposed to age discrimination claims that cost even more. Your manager thinks they're being friendly. They're acknowledging the employee's experience. The comment feels like conversation. Under federal anti-discrimination law, harassment is unlawful and gets even worse when it is severe or pervasive enough to create an intimidating, hostile, or abusive work environment. When managers make age-related comments at social events, they create documented evidence of age bias that plaintiffs' attorneys use to build discrimination cases. But here's what the EEOC looks at: pattern and context. If your manager comments on someone's age at the holiday party, then that employee gets passed over for a project lead role 2 months later, the EEOC investigates whether age was a factor in the decision. The holiday party comment becomes the smoking gun. Age discrimination settlements follow the same statutory damage caps as other discrimination claims, ranging from $50,000 to $300,000 depending on employer size, plus back pay and benefits, attorney's fees, and costs. But age cases often include front pay as well, compensation for future lost earnings, which can double the settlement amount. After all, older employees have a harder time landing jobs as they approach retirement age. The problem gets exponentially worse when multiple managers make similar comments. Once the EEOC identifies a pattern, they investigate your entire promotion and termination history for age bias. Here's the protocol. First, train managers never to mention age, retirement plans, being overqualified, or generational differences at any work event. Second, ban phrases like old-timer, new blood, fresh perspective, or anything that references someone's age relative to their work. Third, if discussing someone's tenure, focus only on their accomplishments. You've been instrumental in building our client relationships, not you've been here since the old days. Fourth, if employees bring up their own retirement plans, acknowledge neutrally without commentary on age. Thanks for giving us a heads up on your timeline. Now your age comments are eliminated, but there's a religious discrimination trap that plaintiffs' attorneys specifically look for. Your manager thinks they're being inclusive by being curious about other religions. They're acknowledging diversity. The comment feels well-intentioned. According to EEOC guidance on religious discrimination, it's illegal to harass a person because of their religion, and harassment can include offensive remarks about a person's religious beliefs or practices. Even well-meaning comments that single out someone's religion or religious practices can create hostile environment claims if they're severe or pervasive enough. You don't have to discriminate in hiring or firing to violate religious discrimination laws. Building a culture where an employee feels seriously singled out or othered because of their religion creates EEOC liability. According to employment attorneys who handle these cases, not everyone celebrates Christmas, and holiday parties can create particular dangers when religious differences are highlighted or commented upon. The violation gets worse when managers make assumptions. Asking a Jewish employee about Hanukkah like it's some exotic event, assuming someone is Christian because they're white, or asking Muslim employees to explain their confusing holidays, all of these create evidence of religious differentiation that becomes problematic in EEOC investigations. Here's how these cases develop. Manager makes religious comment at a holiday party, employee feels singled out. 6 months later, that employee applies for promotion and doesn't get it. They file EEOC charge alleging religious discrimination, citing the holiday party comment as evidence that they were treated as an outsider. Religious discrimination settlements typically range from $50,000 to $100,000 or more, depending on employer size and case specifics. Sounds far-fetched? It's not. And claims like these are filed every single day. Here's what protects you. First, call it a holiday party or a year-end celebration, never a Christmas party. Second, train managers never to ask about or comment on anyone's religious beliefs, practices, or holidays they do or don't celebrate. Third, if you're doing a gift exchange, make it completely secular. No religious-themed gifts, no assumptions about what people celebrate. Fourth, if employees voluntarily share their religious practices, managers should respond neutrally. Thanks for sharing that with me. It's always exciting to learn about different cultures and religions and move on without questions or commentary. Fifth, remind managers that comments starting with "you people" or "your religion" are never appropriate, even in friendly conversation, because they carry an otherness judgment to them. Your religious comments are compliant now, but there are more statements that trigger instant EEOC liability that most managers don't even realize are dangerous. Your manager thinks they're motivating employees. They're praising work ethic. The comment feels like performance feedback. But here's what creates sex or familial status discrimination liability. Comments that connect family status to work performance or career advancement are evidence that the manager uses family status as a factor in employment decisions. And often, that gets taken a step further and is linked to sex, as women are more likely to assume caregiver responsibilities than men. The EEOC examines the context and nature of conduct when investigating harassment claims. When managers link family responsibilities to performance expectations or career potential, they create a record of bias that becomes powerful evidence in discrimination cases. The EEOC looks at patterns. If your manager comments that people with kids can't handle certain assignments, then later passes over for parents for promotions, That's direct evidence of family status discrimination. These cases settle in the same ranges as other sex discrimination claims, typically $50,000 to $300,000 depending on employer size. Real world scenario. Manager makes comment at holiday party about single employees being more dedicated. 3 months later, assigns a major project with promotion and compensation upside to a single employee despite a working impairment being more qualified. The employee who is passed over files an EEOC charge. Manager's holiday party statement is quoted in the complaint as evidence of bias. Here's what HR teams need to implement. First, train managers never to comment on employees' marital status, parental status, or family obligations in any context, positive or negative. Second, ban any language that suggests certain family situations are better or worse for career advancement. Third, if discussing work schedules or project assignments, focus only on business requirements without mentioning anyone's personal situation. Fourth, remind managers that complimenting single or childless employees by contrasting them with parents is still discrimination. Your manager comments on employees' physical appearance, attractiveness, or clothing choices at the holiday party. Even compliments can cross the line when they sexualize employees or focus on physical attributes rather than professional accomplishments. According to EEOC standards, sexual harassment includes unwelcome conduct of a sexual nature, and harassment claims get even worse when the conduct is severe or pervasive enough to create a hostile work environment. In a recent case from 2024, a senior official at the Tulare County Public Defender's Office allegedly engaged in inappropriate conduct at an office holiday party, leading to a sexual harassment complaint and a 6-figure settlement after years of unchecked harassment. The problem compounds when appearance comments lead to workplace treatment changes. If a manager compliments a female employee's party appearance, then later gives her client-facing assignments because she presents well, that's evidence the manager is making decisions based on sex and appearance rather than qualifications. According to EEOC enforcement data, in fiscal year 2023 alone, the EEOC recovered over $60 million for violations of Title VII involving sex harassment. Individual settlements for sexual harassment claims, including those originating from company social events, regularly reach $50,000 to $100,000 or more. Here's the protocol. First, train managers that any comments about employees' physical appearance, attractiveness, clothing choices, or bodies are prohibited at all work events. Second, if managers want to give compliments, focus exclusively on professional accomplishments. Great work on the Henderson account, not, you look great tonight. Third, absolutely prohibit comments about what employees should wear to work, how they look different outside of work, or anything related to spouses or dating. It's often tied to what managers think a man or a woman should look and dress like. Often, a man can look sloppy and no one will bat an eye, but a woman forgets her makeup and all of a sudden everyone's got something to say. Fourth, ban all alcohol-fueled compliments that reference physical appearance, dating status, or anything sexual in nature. Fifth, implement a zero-tolerance policy. Managers who make appearance-based comments at company events face immediate corrective action because these statements are the foundation of sexual harassment lawsuits. And critically, ensure your company takes immediate action when harassment is reported. In the Elite Wireless case, the company's failure to act on harassment reports after the holiday party incident was a key factor in the EEOC's lawsuit. Swift response to complaints can be the difference between a correctable situation and a 6-figure settlement. Remember, pregnancy and family planning comments open you to $50,000 plus sex discrimination claims. Age-related statements could trigger $50,000 to $100,000 plus in age discrimination liability. Religious comments create $50,000 plus in hostile work environment claims. Family status remarks cost $50,000 plus in sex discrimination settlements, and appearance-based comments could cost $107,000 plus in sexual harassment lawsuits based on recent EEOC enforcement action. Here's the math that matters. Pre-event manager training typically costs $2,000 to $3,000 per session. The average discrimination settlement ranges from $50,000 to $300,000 depending on employer size, and the EEOC recovered over $60 million in fiscal year 2023 for sex harassment violations alone. One manager's inappropriate holiday party comment cost more than 20 years of prevention training. The math isn't even close. This is exactly what I review for HR departments before EEOC charges arrive, because fixing these problems after a discrimination complaint costs 50 times more than preventing them. HR professionals, you are the front line when it comes to protecting your company from social event-based discrimination claims. Even the most experienced managers can miss hidden traps buried in what feels like friendly holiday conversation. If your company is hosting holiday parties this season, especially without pre-event manager briefings or clear social media policies about company events, getting a workplace culture review could be the difference between team building and an $80,000 EEOC charge. A proper social event compliance review can bring you peace of mind, protect your company from regulatory enforcement, and reinforce the excellent work your HR team is already doing. If you're unsure about your current policies for company social events or manager training on discrimination at work functions, you may want to consult with a qualified employment attorney who can evaluate your specific situation. The link to schedule a workplace compliance review is in the description below. Let's make sure your holiday celebrations follow federal regulations, support your team culture, and protect your business from preventable discrimination claims. Thanks for watching, and thank you for doing the hard work of building compliant, people-first workplaces.